first want to thank you all for being here, for coming in and spending an hour, or not quite an hour, I guess 40 minutes now, with an attorney. I know most people don't like attorneys and don't like to deal with attorneys, and I don't either, so I understand that. But anyway, thank you all for being here. I really appreciate it. The goal of my talk today is to help you come away understanding some legal issues that are involved with cybersecurity, and to be able to use some of what I tell you today as arguments within your organization when you get pushback on certain things, certain steps you want to take, processes you want to implement, what have you, to be able to help further explain just how serious of a risk cybersecurity is to every organization. So the first question I want to ask is, how many of you have been involved in a data breach within an organization before? And it doesn't have to be the one you're at now. Okay. For those of you who raised your hands, I bet you can guess why I have the image of a building on fire playing in the background. Right? Who wants to take a guess? Somebody want to answer that question? Why does Shawn have the image of a building on fire in the background? Yes, sir.
That's how management treats.
Good answer. What's that?
So that's pretty much what happens to the company. They're having a fire sale.
That's right. Well, that's a great answer. Whenever you're going through a data breach or a cyber incident, it's like being in a building that's on fire. You're trying to get out. You're dealing with chaos. There's calamity all around. There's panic. There's no longer rational decision making. It's just trying to get the heck out of the building and solve the problem as quickly as possible, which is immediately is getting out. It's panic. It's catastrophic on business operations. This is what I see as an attorney who counsels clients on the front end. I've been doing this since 1998. I've been involved in cyber law. I thought Y2K was going to be my ticket to stardom. Y'all want to guess how that turned out? Right. Okay. That's how it turned out. Y2K wasn't the next big thing we thought it was going to be. So I've been involved in, but it did get me in cyber. And I've been trying to figure it out ever since. And each day I still wake up asking myself, how much more do I have to learn today? Because I still know there's a lot more out there that I don't know than there is that I do know. But my role now is helping businesses on the front end implement risk management programs and try and be better prepared from a legal and regulatory standpoint for this risk. And on the back end, when they do have a breach or an incident, to counsel them through that process and help them navigate the regulatory and legal hurdles that they have to deal with. Unfortunately, I do a lot more of the latter work right now than I do the former, because I still can't get businesses to wake up and do what they need to do on the front end. But I get them to on the back end, because I handle about 40 to 50 breaches a year. Right now I have several active ransomware cases going on that every single person involved would give anything to be able to go back in time and to have put the protections in place a couple of months ago that would have saved them many times from what they're dealing with right now. So, it's a crisis, and I have to counsel them through that, so I know what they're going through. It's like this building on fire. So I'm sure you're wondering, what's a lawyer's role in cybersecurity? Why do I have a lawyer up here talking to me right now about cybersecurity? And so I want to ask you another question. Well, first let me ask you this. Were any of you involved in the Ashley Madison data breach? Any hands up? Come on, anybody? All right, good. I just had to make sure you're awake after lunch. But I'll tell you why. Why do you think you know about all those companies that just flashed up on the screen? Lawsuits is one. Reputation, public disclosure. Because it's not that they wanted to be good corporate citizens and just decided, you know what, we had this really bad incident, turned into a breach, and we're going to go out and tell the world all about it because we're good people and that's what ethics and morals require. You think that's what happened? Absolutely not. It's because there are laws that mandate that when you have a breach, you must disclose it. You must report it. You must provide credit monitoring services in some cases. All these things are a product of law. So, I have a little saying that I've come up with. Security and IT protect companies' data. Legal protects companies from their data. Think about that. Data is the hot potato these days. That's pretty good, isn't it? Data is the hot potato. I'm going to have to remember that one. All right. It is. Data is the hot potato these days. Nobody wants to hold it because it carries so much risk and liability with it, so much responsibility for protecting it. And when you mess up, you have to go through all of these other problems as a product of it. So the goal of legal is to help protect companies from the legal and regulatory and reputational and just business partnerships type risks that come along with it. And that brings me to another one, and I wish I could say I made this one up myself, but I've heard many other people say it as well. And that is cybersecurity is no longer just an IT issue. It is now an overall business risk issue. And it's something that must be discussed, dealt with, and communicated within all levels of management. It's no longer the day of just having the CISO sitting in the corner over there dealing with it all by himself. Or the CTO dealing with it all by herself, or whoever else. Whoever's responsible for protecting the company, their network, and their data has to have active involvement with other areas of the organization. One of the primary ones, I believe, is legal. In-house legal counsel needs to be involved in this because this is a business risk. It is a business risk that must be managed like any other business risk. And legal is particularly good at managing risk. You see, security is a lot like legal. Think about this now, all right? IT, in a truest sense, is like marketing within a company. They make stuff happen. Security is a lot like legal. We stop stuff from happening. And people don't like that a lot of times, but our job is to stop bad things from happening, whether it's in legal or security. So you need to have your legal team playing an active role. And a shameless plug is if you don't have your legal team, you need somebody on the outside to help with that. And there's plenty of good attorneys that do that. I hope that I'm one of them. But let's talk about the legal obligations for a second. You have the international obligations. We used to have this thing called safe harbor, which up until a year and a half, 2 years ago, was how U.S. companies were able to handle and manage data of EU citizens. Okay? Then that got struck down, and we had this thing called Privacy Shield that came in. That's going to have a fairly short lifespan because we have this thing called the GDPR, the General Data Protection Regulation, coming out of the EU. It takes place, it's effective May, I think 18th of 2018. And it's like 170 pages of regulations of how data has to be protected and managed if you're dealing with residents of the EU. Or if you're in the EU or you have offices in the EU. Okay? Then we have federal laws. We have the one everybody knows about, HIPAA for healthcare. We have Gramm-Leach-Bliley. We have FERPA for education. These are privacy laws that govern how to protect data. but they also have security components to them. They go hand in hand. Privacy and security go hand in hand. Without security, you have no privacy. Security is what protects the privacy of private data. Okay. You have the FTC regulating in this space. They're kind of the big, I don't want to say bully on the block, but they're the big guy on the block right now in the world of cybersecurity regulation. Then you have the FCC and the SEC that's taking a very active role trying to catch up with the FTC. You have state laws. Right now we have 48 states that have data breach notification laws. Many of those have a cybersecurity component to them as well. So if your company does business in 48 states, and these 48 states, and you have an incident involving personally identifiable information of individuals that are residents of each of these states, you have to notify in compliance with every law, every one of those jurisdictions. That can be very time consuming. And I will tell you, I was in Washington, D.C. in May, sitting in the House and the Senate having meetings about getting a national breach notification law, and I was told it will never happen. So these 48 states, we're going to keep them. Get used to it. Then we have this thing called the New York Department of Financial Services cybersecurity regulations. How many of you have heard of that and are aware of it? Okay, good. This is very good. Then we have Colorado following suit saying, if New York's going to regulate financial services organizations' security practices, so are we. Well, what do y'all think is going to happen in the great state of Texas? Or in every other state that has an active legislature that wants to show they're solving problems? We're going to have 48 cybersecurity standards before it's all over with. And they're not all going to be consistent because they're not all consistent right now. So this is a huge legal issue, but what does it mean to you? It means your organization has to know what it's governed by. What rules, what laws, what jurisdictions, what data it has, where that data is, who are the data subjects. You have to know that these days. Just saying, I'm not worried about all that, it doesn't pass anymore. Long gone are the days of, you know, the memes on Facebook? You have like the meme of the little grandma saying, I don't do that Facebook stuff. Have y'all ever seen that one? It's hilarious. All right, you have people sitting in organizations right now, sometimes in IT or security roles, saying, I don't do that stuff. I don't do that cyber stuff. It's no longer an excuse. We're all aware of the problem. We're all aware of the consequences. We have to pay attention to it and have to deal with it. You have industry groups. I'm sure most of you are familiar with PCI and have to deal with PCI compliance. We have FINRA regulations. There's a whole lot of other stuff. There's banking regulations. There's all kinds of stuff out there. You've got to know your industry. And then we have an area that oftentimes gets overlooked. It's our contracts, business contracts. How many of you know whether within your organization, IT or security, has a role in the contracting process? When a contract is received that has these little things called the Privacy and Data Security Addendum, or Privacy Addendum, or any number of names. There's always some, but many times it's longer than the contract. A lot of organizations don't even bring the people into the process that are charged with securing the data. They just sign them and go on about their business and think this is no big deal until someone shows up for an audit and they're sitting at the front door and they're like, well, what are you here for? I'm here to audit your security. Oh, get out of here. You can't do that. Well, sure. Here, it's in the contract. But we're not an IT company. We're not a technology company. We just do marketing. Well, you still get our data, so we have an obligation to come make sure you protect it. This is a dialogue that goes on. far too often. And I know that because I get calls from the smaller businesses that are going, oh my God, you're not going to believe what they want us to do. And so I tell them, well, do you understand that the SEC requires them to do this? Do you understand that New York Department of Financial Services regulations requires them to do this? Do you understand that HIPAA requires them to do this? Oh, I've never heard of such a thing. Of course you haven't. You're going to lose your biggest customer now because you're not paying attention to what you need to be paying attention to. Okay? Your contracts are critical. I see more law being made by contracts these days than I do some of the crazy things our legislatures give us. Okay? Because it's the rules, the law between the parties of what they agree to. There are some organizations in certain industries that require notification within 15 minutes of learning you've had an incident, not a breach, an incident involving their data. 15 minutes. You're contractually required to notify them that there's been an incident involving their data. Are your organizations keeping track of that and prepared to meet such response obligations? I'd like to say yes, but I know the real answer is probably not. Is it going to bite you every time? Probably not. But I'll tell you what, I'm dealing with a case right now involving third-party risk where I'm representing a company that went through a breach and they have data belonging to someone else that's really sensitive. And now they're having to answer those questions. It's tough. It's tough. And I represent companies all over the world, so you're not going to be able to pick out who it is. But anyway, it's a very uncomfortable conversation. And the CISO of the company told me, he said, I want to go out and talk about this. I want to go tell others in my position what it's done, how difficult it's been on us. And I said, that's great, but you're not doing it right now. We're going to get the legal stuff and the investigations behind us, and then you can go out and talk about it, okay? But right now, no. But it impressed upon him so strongly the need to share with others, because 2-3 months ago, he didn't think this was that big of a deal either. Now they're running and looking at contracts going, oh my goodness, we're required to do this, we're required to do that. Like, yeah, that's why I kept telling you all this, you know? You got to take this serious. So, one of my favorite slides, and I don't want to be the guy selling FUD, okay? I'm not the guy telling you you're going to be breached and it's going to take your company down. I'm trying to give you hope and give you some ideas and some things to do to not end up in that position. But let me tell you, back in 2013, 2014, I was a FUD seller too. I'd use the old, it's not a matter of if, but when all the time and all that good stuff. And then I realized it was having a negative effect because I was going to companies and talking to them and trying to get them to take a risk seriously when I was telling them it's not a matter of if, but when you're attacked. And when you're attacked, it's going to be devastating and you're going to be out of business. And you know what their response was? Then why should I do anything? Why should I go through the process? And at the end of 2014, I read this report from the Online Trust Alliance that said, looked at all the breaches that had been reported in the previous year and found 90% of them were not the Russians sneaking in through the coffee makers and the lights. It was people losing USB drives. It was spear phishing of all things. Phishing emails were the cause of more of these breaches than anything else. It was poor password policies, okay, or no password policies. It was that kind of stuff. It was failure to install security updates. Anybody see anything in the news about that recently over the last few months? Or running outdated systems that were no longer supported? Yeah, WannaCry. These are not super sophisticated, cool James Bond kind of stuff that we like to talk about at cocktail parties. These are basics. There's no excuse for not doing many of these things and for allowing this to happen. These aren't always big spends within the organization. It's a matter of caring. Do your people care about what they're doing? It's training your workforce. Teaching them to not click on those emails. Phishing them. Trust me, I know. We get phished at my firm. I'm the one that pushed for it. And I've almost gotten burned by it, okay? I've almost clicked on one myself that was a fake LinkedIn invite. And fortunately, I was at a conference much like this, and I'd gotten a couple of LinkedIn invites, and so they were all there next to each other, and I could see there was one a little bit different. That was the only thing that saved me, or I'd have been clicking accept to. I mean, we're all vulnerable at some level. We can't get to 100% security, but if we can get from 30 to 50, we're doing a lot better. If we can get from 50 to 70, we're really narrowing this risk gap a lot. So don't buy into the whole notion of we can't do anything because we can't afford to do everything. Nobody can do everything, but you can take steps that are reasonable. Now, I have up here what I believe is a list of common cybersecurity best practices. And I'll tell you, I didn't come up with them all on my own. I'm a lawyer, just a lawyer, but I did borrow freely from the legislation that was recently proposed in the Senate to talk about cybersecurity best practices. Many of these are on there. But many of these come from cases I've read about, legal cases, where courts and regulatory agencies have looked at them and found deficiencies because they didn't have these kind of things in place. And by the way, I will upload this slide deck to my website after today, and you're more than welcome to get it, use it, borrow it, whatever you want to do. When I put something out, it's for information. I want people to be able to find value in it. So ShawnETuma.com is the easiest place to get it. It's just a blog. There's nothing for sale there. But here's a couple of the cases we've seen that have looked at this. One, let me ask you this question. Does your company have reasonable cybersecurity? Who can answer that with a definitive yes? We have reasonable cybersecurity. What is reasonable? Anybody at any given time playing Monday morning quarterback, which is what we lawyers do when we're suing somebody, after the fact will say, well, you should have done this, you should have done that, you should have done this. Why didn't you do that? How much would it have cost to have done that? Oh, you didn't care about protecting my client's data enough to have workforce training. Oh, you don't even care about my client, do you? You know, you're saving money, huh? Yeah, that's the kind of games we play with everything on this list. Well, in the Target case, the court found, it didn't go to trial, but at least in a preliminary ruling, that companies have a duty to have reasonable cybersecurity. In the FTC versus Wyndham case that went up to the Third Circuit Court of Appeals a couple of years ago, the court found that Wyndham did not have reasonable cybersecurity in place that led to 3 breaches that cost them a ton of money. So you know what Wyndham argued? They said, how are we supposed to know what reasonable is? We did this, we did that. How are we supposed to know what reasonable is? You know what the FTC came back with and that made its way into the opinion? Well, back in 2007, we put this guide on our website about security steps companies should take. And it had this, this, and this in there, and you didn't do it. So you should have known. We put this guide up on our website. That's the rule. That's became part of the law. All right? I don't know what reasonable is. Reasonable varies by every single organization. So if somebody's out there selling you a one-stop shop product that does everything in the world, is it really tailored to your organization? Does it really meet your risk needs? I don't know. That's why I put risk assessment at the very top. Because I think every organization has unique needs, unique risks. And reasonable is tailored to the organization. Your size, your wealth, your market, your data, all of it. You've got to look at all of it. But this wasn't the only case. Does your company have adequate internal network controls? How many of you have heard of the LabMD case? The good old FTC LabMD case. Now look, there's a little bit of FUD to this case, okay? It's an outlier. It's a little bit of an outlier because it became fairly personal between the FTC and the head of LabMD. But the facts giving rise to it are very serious and very, very legitimate concerns arise from this. But I don't think it's something we'll see all the time. In LabMD, we had a cancer research facility that employed about 25, 26 people. And they had, they did research on like prostate cancer and stuff like this, did a really good job. And one employee in their network back in, I think it was 2010, was using this program called LimeWire. Anybody ever heard of LimeWire? None of you have ever used it, right? Of course not. Yeah. They had LimeWire on their network. Nobody else knew about it. And LimeWire is a peer-to-peer file sharing program. And it had connected as a shared folder, a folder that had a report in it with like 1,900 patients' payment information and billing and stuff like that. And so that report was in a shared folder that never went anywhere at that point. But there was this cybersecurity firm called called Taversa. And Taversa figured out a way to go troll the LimeWire users and see what they were sharing, and they found this report in the network. And so they got it, and they called LabMD and said, for like 25 grand or something, we'll tell you how we got this, and we'll tell you how to fix it. Sounds a lot like ransomware, doesn't it? And so LabMD told them exactly what they could do, and I'm not going to repeat it here. But Taversa then went to the FTC, turned it over to their friends at the FTC, who opened an investigation, pursued LabMD until in 2014 they went out of business. They're still going after the owner of LabMD, and it's in the 11th Circuit Court of Appeals right now. Where did all this start at? It started at a company not having control over its network, not knowing how its data is protected, not knowing the vulnerabilities. So you've got to have control over your network. Does your company have written policies and procedures that are focused on cybersecurity? In the case of RT Jones, the SEC went after this company because it found they didn't, and that was indicative of them not caring enough about investors' data to protect it. Now think about this. We all talk about the human factor. We all talk about the insider risk and negligence and all this stuff. How do you expect people to protect your data if you don't tell them how to protect your data? Think about that. Are they clairvoyant? No. You've got to tell them. You've got to give them the rules and guidelines. That's your policies and procedures. It's the rules and guidelines. And then I believe in training them on those. And with my clients, that's what I do. I draft them, and then we go through an hour video training on the policies and procedures so they understand what's in there and why it's in there. And if it's not suitable for training your people from, it's not suitable for being part of your company. You need better policies and procedures. And I don't mean more complicated or tricked up. It's got to be something that's effective on putting people on notice and educating them. In this same case, does your company have a written incident response plan? In this same case, the SEC found the company liable for poor data security practices because they did not have a written incident response plan in place. Their reasoning was, things happen. Things happen. Having an incident response plan is what keeps a small thing from becoming a large thing. If you really care about your customers' data, then you will be ready for that oops moment to take proper precautions so you're not in the building on fire when it happens, okay? You need a written incident response plan. Does your company manage third-party cyber risk? Do you even know what it is? Do the people who should be managing it even know what third-party risk is? Okay, this is a big issue because we all have some place in the supply chain, some role. And if we're not checking out to see how other people are protecting our data, then we're not protecting our data. Okay? And let me dispel one crazy notion right here, right now. When you entrust your data to someone else, they do not become responsible for it and you lose responsibility. You do not abrogate your responsibility to someone else. Okay? There's a lot of myths out there about that in the security world. Trusting it to a cloud provider doesn't mean you're no longer responsible for it legally. Trusting it to a downstream business partner doesn't mean you're not responsible for it. Here's what it means. If I have data that I'm the holder, the collector of that data, I'm responsible for it. If I entrust it to someone else, I should have a contract in place that says, now you're going to be responsible for safekeeping and indemnifications and all that other stuff. And if something happens to it, you're going to be responsible for the response process and the fines and penalties and everything else. And usually they'll say, sure, no problem. Here, let me sign it. And what happens when something goes bad? Who do the regulators come to look to? Who do the attorneys file suit against? Me. I'm still liable. I have a contractual right against that third party. And you know how much that contractual right is worth to Target when Fazio Mechanical probably isn't worth the heating and cooling bill of one of their stores? It's not worth anything. It's just a contract. Okay? You're still responsible for it. So you have to be responsible for protecting your own data. And when you entrust it to someone else, you need to do what was required in this GMR case. And the court said, or the FTC in the enforcement rule said, you are obligated to investigate their cybersecurity practices. You're obligated to bind them contractually, and you're obligated to audit them to make sure they are doing what they said they would do. No way around it. How mature is your cyber risk management program? That's a good one, isn't it? Mature cyber risk management program. In this GMR case, and in a new FTC case that came out a couple of weeks ago, they repeated this, that once companies have had a problem, they establish and implement a cyber risk management program that is continuously being matured over the course of time from now into the next 20 years when they'll still be overseeing these companies. Okay? You need it. You need it. It's no longer a matter of just saying, I don't do that stuff, or, oh, we have an IT guy, oh, or we do this, or we do that. You've got to take it serious. The New York Department of Financial Services cybersecurity regulations came into effect in March of this year. This slide is an overview slide, obviously, but I know a lot of you are thinking, well, I'm not in New York and I'm not in the financial services industry. Well, what's interesting is it requires a cyber risk management program, a cybersecurity program. and it requires companies who are regulated to have contractual agreements in places with their third-party business partners who deal with any IT or data transfer issues that are similar to what they're held to. So they have to pass it down. If I have to abide by those standards, so do you. So anybody that has the data, wherever it goes, or access. Now, think about how many businesses are in New York in the financial services industry. You already can think of a lot of them. And it also applies to insurance companies. But there's something else I want to tell you. It includes things like bail bondsmen, check cashers, contract service providers, you name it. It flows down. So this rule is big. I've only got like 2 minutes left. I'm sorry for that. I'm going to slip through this. The GDPR is coming. Very, very big. Need to pay attention to that one. There's a lot of obligations in there you've got to be ready for. You're not going to do it at the last minute. How mature is your cyber risk management program? How do you bring peace, love, and harmony to your organization? Like you're sitting in this picture right here. You know, breathe in, all that good stuff. Here's how I think you do it. You have a program in place that accomplishes these goals. And again, I'll share the slides afterwards, so I'm just going to zip through. What does that program look like? I'll tell you what mine looks like. It involves a risk assessment at the beginning, statement of objectives, our privilege issues that we attorneys have, board meeting proposed minutes, board meeting questions, all kind of good things like that. And and a little checklist there. But one last thing I want to talk about is cyber insurance. I can't leave here without telling you about cyber insurance. You've got to look into cyber insurance. It may not be appropriate for everyone, but it needs to be considered because it can be a lifesaver for a lot of small to mid-sized companies. Larger companies can usually absorb it. Smaller companies, you know, they can't. They don't have the financial wherewithal to do the things that are necessary to respond to an incident in a way that will keep it from becoming a catastrophic breach. There are a lot of tricks to cyber insurance. Here's just some bullet points to look at. I will tell you this, if you do not know that you have cyber insurance, you probably don't have it. Okay, you've got to know you have it and have your legal counsel look at it. Now, this is my last little saying for you, and I want you to think about this as you close out the day. You don't drown by falling into the water. You drown by failing to get out. Incidents happen. Problems happen within an organization. Breaches happen. But they don't have to be catastrophic. They become catastrophic when you're not prepared for them. So your task for today is to get out there and learn to swim. Thank you all. And I know there's another panel coming up, but I'm going to be around outside. If anybody has any questions, I'm happy to answer.